Hi, everyone. Good morning. My name is Jade Calver. This morning, thank you so much for joining. And if you're watching this after the recording, thank you so much for joining my seminar this morning. Today, I'll be talking about navigating inspections and audits under the Temporary Foreign Worker Program. So if you are just joining us, we are a Canadian immigration firm. I own and operate Calver Immigration Consulting Inc. It is a full-service immigration firm. We help clients across Canada and globally with their immigration matters. So whether you're looking for temporary residency, you're an employer looking to navigate the Temporary Foreign Worker Program, or someone looking for help with a more detailed immigration case, we're here to help you. I have been in the industry for well over a decade at this point, and we help employers both who are large corporations as well as small startups, small mom and pop shops who are looking to bring in some workers for their business. If you're a Canadian employer, we're here to help. So today I will be talking about inspections and audits under the program, as I mentioned earlier. So if you didn't catch it last time, I also posted it on my YouTube channel. I have a seminar that goes over the Temporary Foreign Worker Program. So just to recap, the Temporary Foreign Worker Program is the program that examines the effects of hiring foreign workers on the labor market. So you'll hear the term LMIA a lot. So LMIAs are what most employers need to bring in and hire foreign workers. So they issued these authorizations, which is called the LMIA, to hire foreign workers. You'll hear the terms Service Canada or ESDC used. They're interchangeable. It both refers to the same entity, so it's the Canadian Labour Department, effectively, that reviews the labor opinions for companies. So the whole idea is that in order to get your foreign worker work permit, you need to go through Service Canada's Temporary Foreign Worker Program to get an LMIA. So with today's labor market, the LMIA is quite, wouldn't say easy to get, but it's a lot easier than it was 5, 10, 15 years ago when we were doing LMIAs. And so the idea is that, of course, we know that the labor shortage is growing year after year in the Canadian market. And so these LMIAs are becoming easier to get. Most of my LMIAs, I would say these days, are approved without an interview, which is good, and also from an immigration representative standpoint, bad, because if you are applying for these LMIAs and they're reviewing these LMIA applications and you're going through it without any interview and also without speaking to an officer about the requirements of the program, then what happens is that you get an LMIA, and then most employers, they think, great, I'm approved, that's it from me. However, I thought I would do the seminar because I think that with how popular the LMIA is becoming, for a few reasons that I'll get into shortly, there's a lot of misunderstanding about what you're actually committing yourself to as an employer. So my point here is that once you have the LMIA, you're not off the hook as an employer. For the entire duration and even after, with regards to record maintaining, as an employer, you have to make sure that you're compliant with the labor market assessment. So you need to look at the terms and conditions on your LMIA. There are terms on the decision letter that they send to you, as well as in the annexes of the decision letter. There's also within the immigration and refugee protection regulations. So you just need to be careful because you want to make sure that you are compliant with the regulations when it comes to your LMIA. And so just to build on that, you also have to keep your records for 6 years beginning on the first day that your worker is employed all the way up to 6 years past that date. So when it comes to the documents you have to keep, we want documents related to the LMIA. So that can include all of your advertising, all of your job offers, your application forms, documents related to the conditions set out in the regulations. So this can be your pay slips for your workers. If you have to provide accommodation, you have to include proof of accommodation. Flights is a big one, proof that you paid for flights for your workers to and from Canada, as well as healthcare. So proof that you covered healthcare for the workers before they're eligible for the provincial healthcare. So, as you can see, there is quite a lot of regulation that you have to be mindful of when it comes to the conditions outlined in the LMIA decision letter, as well as its annexes. So you just have to be mindful again of that. So, when it comes to the requirement to inform, so we have a lot of employers who they come to us, they've either done their own LMIA or maybe someone else has done it for them, and they just haven't been told about these requirements. So again, if you think about the requirements, so within the temporary foreign worker program, a big one is wages. So you have to pay the median wage for that occupation that you've hired the foreign worker in for your region. If you pay, so you say that you have to pay them that much money. If, for example, you promote them too much or demote them too much and that they're not being paid close to what you offered in the LMIA application, then you're going to be considered non-compliant with your LMIA. Same thing if you, in your LMIA, have said that you're going to provide accommodation for your foreign worker, but then you actually don't provide it and you say you have to go find your own apartment, then that's going to be an issue as well. So there is a requirement to inform. There will also be a location on your LMIA. If you change addresses, you also have to proactively inform. I'll go through all of the different changes that can happen when it comes to an LMIA that you have to advise ESDC of. So I just wanted to bring this up because you do have the duty to inform Service Canada proactively. I find that employers who do this, you can always go to Service Canada and ask them questions. For example, if you are changing the location or job duties slightly, you can go and ask them and say, do I have to get a new LMIA if I do this? Or am I okay to keep the person working on this LMIA? So again, just that duty to inform exists within the Service Canada Temporary Foreign Worker Program. Reasons why you may be inspected as an employer. So the first three are the real ones. So first is if Service Canada suspects non-compliance. So this is usually because there is a tip from a foreign worker in your workplace that you are not compliant. It can also be because a worker has submitted a work permit application and maybe IRCC has flagged the you as an employer. And so what happens is that you will get a letter, usually via email. The two other reasons that you might be inspected is that if you have previous non-compliance issues before with any of your LMIAs, you can usually expect to be inspected more often. It can also be a random selection. I have employers who are just selected at random from time to time, in which case there's nothing you can do about it and there's nothing you did wrong. You were just selected at random for a compliance inspection. There's a couple others, but they're mostly related to COVID requirements, so I wouldn't pay too much attention to the last two. So what happens is that you will get an email and they'll say why you were inspected, so one of those reasons, and then they'll say, they'll say what exactly they want to inspect. If there was a tip, then they might say, we want to inspect, for example, your pay slips. If it's a random inspection, they'll usually just send you an email asking for, proof of your pay slips for your, for your employees and your T4 slips for the last year or so, whatever the period that the foreign worker was working for you for. And so if you look at the regulations, Service Canada actually has quite a lot of authority. So they can inspect the letter and the information on your LMIA letter. They can inspect the treatment of your temporary foreign workers up to 6 years after the foreign worker started working. So remember, even if your foreign worker gets permanent residency, they can still come back and inspect the conditions of the workplace. They can interview the foreign workers as well as the other employees to confirm you're compliant with the program. Inspections, as I said, they're usually virtual. They only become in person if they see something that they don't like in your written documentation that you send back to them. It can be announced or unannounced. Usually, this is only if there are serious concerns about health and safety conditions for the workers. So generally, that's quite rare, but I have seen it happen to some employers, especially some larger employers who, did have some compliance issues. What is reviewed during an inspection? So the inspectors can look at a few different factors. So there's making sure that you're compliant with the federal and mostly the Provincial Employment Standards Act as per your province. They want to make sure that you're still engaged in the same business. So is it still operational? Is there still a job that exists? They want to make sure that the employee is working in the same job that you offered to them. So if you have an employee who is, you sponsored to be a cook, for example, and then they are, working off site, working as a bookkeeper, then you're going to have issues. The big one is the pay for the temporary foreign workers. So it has to be mostly the same. It can't be less than what was in the job offer. It can slightly increase based on inflation and general pay raises. You also have to make sure that you're still paying your foreign worker the same as the Canadians at your workplace who are doing the same job. As I put here, this is a big question around LMIAs. So pay raises can be acceptable up to the current rate of inflation for the year, but the reason for the raise will always be reviewed. So just be careful with your raises. You can't bring someone in on an LMIA at $32 an hour and then give them $45 an hour after 2 weeks. It's just not, it's just not allowable under the program. So just be mindful of the rate of pay for your workers. They can also look at the working conditions, so making sure that the working conditions, so the hours, overtime, etc., that you set out in the job offer are mostly the same. Of course, that you're providing an abuse-free workplace, and then also that if this applied to your LMIA application, so some LMIA applications require you to create jobs for Canadians. Sometimes you've said you'll hire or train Canadians. Sometimes that you'll develop skills or do knowledge transfer. So they can come in and ask and say, what training have you been doing for your Canadians? Again, if it's the low wage program, they may ask about what accommodation have you provided, what have you done to cover the flights, the cost of the flights for the foreign workers. So it's really important, as you can see, that you keep accurate records as an employer. Again, just a last thing, I've already touched on this. So again, they want to see that you had efforts to hire or train Canadians, prove that the information in general is accurate that you provided in the LMIA, and lastly, that you are providing adequate housing. This is only for certain types of applications. What happens, so as you can see, a lot can be reviewed. Generally speaking, not to scare you, for the most part, with our compliance inspections, we just see that employers, they're asked for their pay slips for the worker. They'll double check. They'll say, please confirm that you've communicated this information to the foreign workers, and then that's it. Most of my employers are done after that. Sometimes if there are issues, you may undergo what's called a full audit under the Temporary Foreign Worker Program. in which case you really do have to be careful when it comes to these audits. It honestly can take quite a long time, a year or more in my experience, and they will go through every single aspect of the program and their extensive checklists that you need to go through as an employer. So all of this to say that a compliance inspection is really important that you comply with and show that you're compliant with the program because you want to avoid that audit. As I said here, so what happens after the inspection? So if your inspection is satisfactory, so that's it, they'll just say it's complete. If there are compliance issues, so usually they'll say these are the problems with your inspection, and then they'll usually give you an opportunity to fix the non-compliance issues. If it's your first non-compliance issue, so let's say, all of your Canadian workers were making $22 an hour in the same position and your worker was only making 20 and he should have been promoted to $22 an hour as well, then you can fix it and then that's it. If you don't fix it, then then you're going to have issues. So usually you fix it and then the inspection's complete and that's it. If they don't, then they can they can fine you. There's usually warnings. So you do have to be mindful. I've put some of the consequences of noncompliance here for everyone to look at. So if the government finds you non-compliant, then you could face a warning. There are penalties of up to $100,000. There's the ban list. You don't want to be on that list as an employer. There are some employers that I know who have been banned for the program because they just haven't complied with the requirements. And so this is the wall of shame that's online. You don't want to end up on that list as an employer. And then they could suspend or revoke your past LMIA. So again, just be careful with these compliance issues. You want to make sure that, as you can see, the penalties are steep. So this is why we're talking about it, so that you as an employer can review your compliance under the program. If you're an HR professional, I think that it's really what I see with my larger organizations is that they're so focused on getting the workers, but they really don't pay attention to these compliance issues once they have the workers approved on their LMIAs. So if you are an employer or an employer's representative, really something to think about when it comes to your HR strategy and management, because it is something that, as you can see from these penalties, it's really something to pay attention to. I also lastly wanted to touch on the recent amendments to the regulations for the Immigration and Refugee Protection Act. So there are more changes in this, but the most notable and important to take note of are that first, so you have to show and confirm that you're providing the information to temporary foreign workers about their rights in Canada. There's a leaflet that you have to show. I would have a piece of paper, a declaration from your employee when they first start work that they're signing this document. Next is that you have to provide an employment agreement to the temporary foreign worker. Usually this is included in the LMIA application. So again, they've all signed off on this, so it shouldn't be an issue. You cannot, as an employer, charge or recover fees associated with the LMIA application. This is really, if you're an employer in Canada and you have an employee who's pushing you to do the LMIA, you can't say, okay, fine, you pay for it. You have to be careful with that. And then lastly, I think one of the most important changes here are that you have to provide health insurance and emergency medical care when your workers start working up until they qualify for provincial health care. So this is an additional cost for employers that you have to make sure that you're covering for them. A few takeaway tips. So you want to understand the program requirements before you submit an application. So again, all of these compliance issues can usually be avoided as long as you are taking care of them before you submit an LMIA application. A lot of employers submit and then they're faced with the compliance inspection and they say, well, I didn't know about this. And so if you're an immigration representative watching this, prepare your employers for these compliance inspections, don't try to get them quickly to agree to things and get them quickly through the application process, only to have them unhappy with you at the other end of things. As I said earlier, do an internal compliance review annually. It's a lot better if you catch it as an employer ahead of time before the government does during a compliance check. As I said earlier, proactively declare issues and always check with Service Canada before you change anything when it comes to the employee's conditions at the workplace. So it can be their job title, their duties, their wages, their accommodation. Make sure that you are checking with ESDC before you change any conditions. And remember that a compliance check becomes priority when requested. If they request these things of you, make sure that you are quick to respond, because non-response non-response is just as bad as a response that includes information that shows that you're non-compliant, and you can also get banned for not responding on time. So again, just make sure that it becomes a priority once you get that request. So that is everything for today. I just wanted to note that I also run Levo, which is a training solution for immigration representatives as well as employers. I do an 8-hour intensive LMIA one-on-one training. It is a intensive training with me, and you get an overview and how-to instruction on how to file an LMIA. So I help you to develop your HR strategy. I help to develop the advertising plans, how to go through the LMIA interview, and then how to recruit foreign workers as well as prepare the work permits if you're doing so. So again, this is for employers as well as immigration representatives, so RCICs and lawyers. If you've never done an LMIA before, or maybe you've already been retained for a first LMIA and you're unsure with what to do with it. So again, on levosolutions.ca, you can always book my LMIA training. You can always find me online or DM me on any of my socials. I'm on YouTube as well as LinkedIn and Instagram if you want to connect with us. I am always happy to chat. And again, my immigration practice is online at calverimmigrationservices.com. We are, again, available on all socials. If you have any questions about the LMIA process, maybe you're just starting it as an employer or a representative, it is quite a comprehensive application, but once you get into the swing of things, you can really, I think, put together a really good LMIA application. And then again, looking forward to those compliance issues. Once you understand, what those compliance issues can be, then it really helps you put together that strong LMIA application. So thank you so much for joining. If you are watching me on YouTube, thank you again for watching. You can leave your comments below, and don't forget to subscribe to my channel. And thanks so much, and see you soon.